Thank you. Thank you, Mark. Ladies and gentlemen, distinguished audience. First of all, I want to thank you for the invitation to come to ICD. And I have seen ICD is the House of Arts and Culture. And the fact that you can speak, or that I can speak for such a young audience is very good, Mark, because these are the political responsibles of tomorrow. And they are impregnated by the principles of peace. So I can only support the action as the action of ICD. You will apologize me, my mother tongue is not English, and we can come to Babylonian situations, but I will try to do my best and to explain what is my personal conviction and what is my personal experience in the prevention and the punishment of genocide. I feel free, and saying this in Berlin is a specific meaning. I feel free to speak because when you are in a government, you are not free to speak. Government is a team, and in a team spirit, in a team you have team spirit, what means that there is collegiality, good fellowship, and you don't speak about different opinions that can rise, and you are not speaking about dissenting opinions. And I shall have to speak today about different opinions and dissenting opinions. My intervention is in three parts. Firstly, some principles that I want to bring again in our interest. Secondly, the history of the Belgian experience in the fight against genocide, and some personal conclusions I want to add. Firstly, maybe the principles, the starting point for our parliament and for the politics in Belgium was that, and after viewing the pictures in the precedent presentation, is of course that we cannot accept impunity for this kind of facts. We want to live in a more fair world, and impunity is, in first instance, it was reserved a long time to states that were the traditional subjects of the international law. But in the meantime, we have seen that there is an evolution. Just like you have the evolution of the globalizing of the world, we have with the development of the international criminal law a movement going from a national approach, a national struggle against impunity, to an international struggle against impunity. And international justice has largely progressed thanks to two triggers. The first trigger is the adoption in 1998 of the Rome Statute, and the second is resulting of the creation of the International Criminal Court, as you know, in 2002. But we have to remember in the principles first that the internationalization of criminal law should not, however, decrease the sovereignty of the state. Firstly. Secondly, the international criminal law should be complementary and subsidiary to national jurisdictions. To regulate the state relations, two criteria of empowerment power have been set up. The one of the territoriality, the one of the nationality. The principle of the territoriality entails that each state possesses in absolute and exclusive authority upon its territory, and the principle of the nationality entails that, due to the genuine link between the state and the citizen, a state can also exert its jurisdiction upon them, upon their citizen, whether they are outside or in the state. While territorial jurisdiction of a state is absolute, enforcement that is based on nationality can be conditional to another state's consent, because if your perpetrator is not in your state but in another state, you had to handle with the welcoming state that had to accept the intervention upon its territory. But what happens when the defendant runs away in order to escape to his homeland's justice? Then we have several possibilities. The first possibility is the one of the extradition, where a state hands over to another, upon the latter's request, a person who has been upon its territory and upon which the requesting state wishes to exert its criminal authority. Another possibility, and that was a possibility that my country have chosen, is what we call the universal jurisdiction. This allows a state to exercise its jurisdiction without a direct link with the dispute. The defendant must only be present on a state's territory for the latter to prosecute him. Those norms are depending for what is mainly called the jus cogens. And maybe I can also refer to the Article 53 of the Vienna Convention of 1969. There it is accepted and recognized by the international community of states as norms from which no derogation is permitted, and the jus cogens points the piracy, the slavery, the war crimes, the apartheid, the torture, and also the subject of today, the genocide. The legal framework of the punishment of genocide was developed through the jurisprudence, just as we have seen, of the, not the international criminal courts, but the courts ad hoc for Rwanda and ex-Yugoslavia. And when these mandatory norms are breached, a state can take on a case only for the reason that the perpetrator or the alleged perpetrator is upon its territory, even if there is no link with the presumed infraction. Let me tell now in the second part the Belgian experience. It's a little bit an incredible history. Of course, in 1952, we have implemented in our law system the Geneva Convention. And in 1986, we did the same for the additional protocols. I will let you see that there is a difference in years. It's too much long, and it's for every country too much long. If we take a decision in international right, it had to be implemented immediately in your system. This was not the case, but it was not only the case in Belgium. It's for the major countries all over the world. And then in 1993, Belgium went farther than the implementation of the both acts by deciding to execute its competence to situation in which the defendant was not upon his territory. This is what we call the universal jurisdiction by default. The law of the 16th of June 1993 just make it possible that we can also prosecute these people. In 1999, we will enlarge the system. We will extend this universal competence even to genocide and crime against humanity. And those both laws constitute a foundation of what we can call the Belgian application of universal jurisdiction. However, two elements have encountered strong opposition in the doctrine, but also in the jurisprudence. Firstly, the accepted default, who shocked a lot of people, especially those who think that lawyers, that the defense is something holy. And second element concerned the immunity. The Article 5 of the law of 1909 mentioned, and I give you what is mentioned in our law, immunity relative to official quality of a person doesn't impede the application of the present law. So everybody could at that moment be taken in charge. Therefore, even the highest representatives of state are susceptible to be prosecuted, which goes against current international law. But it was a decision in 1999 of the Parliament. I will come back to the both laws of 1993 and 1999. The 1993 law as something also particular, because its scope comprised war crimes, whether committed during an international or even an internal conflict. This legislation greatly innovated the international instrument which it was supposed to enforce, but our country goes much farther because not only the international armed conflicts were taken into consideration, also the internal one. And the new law also allows judicial pursuit whether or not the defendant is on the Belgian soil. And this possibility was created by a parliamentary initiative, as I said, of 1991. And based upon this new law, we have had an inquiry against Augusto Pinochet, the former dictator of Chile. It was raised in November 1998. As I said, there was a first revision of that very advanced progressive law of 1993 in 1999. Two modifications. Firstly, universal competence of the Belgian judge was extended to the genocide and the crimes against humanity. And here the baseline for the parliamentarians was that the perpetrators of genocide were not safe, not in The Hague, not in Belgium, not anywhere. Secondly, the authors of infractions cannot claim immunity anymore. While complaints against this law have not been numerous, there is a trial that led to the condemnation by the Crown Court in April 2001. It was the moment that I was Minister of Justice, of 4 people accused of taking part in the Rwanda genocide. And this effect will increase plaints. I give you some example of these complaints. Fidel Castro, Saddam Hussein, Laurent Gbagbo, Hissène Habré, Ariel Sharon, and Amos Yaron became the targets of these complaints who were introduced in the Belgian justice. And the complaints deposited against Ariel Sharon while he was Prime Minister of Israel and General Amos Yaron are concerning genocide crimes against humanity, war crimes, and violation of the Geneva Convention for the 1982 massacres in the refugee camps of Shabra and Shatila in Beirut, Lebanon. You can easily understand that this shocked a little bit everybody. That is also the reason why in 2003, 4 years later, we will modify the law of 1999. But the main reason was that in February 2002, Belgium was condemned by the International Court of Justice to cancel the international warrant of arrest that Belgium had launched against Mr. Yerodia while he was Minister of Foreign Affairs of the Democratic Republic of Congo, claiming that this international warrant, that was a decision that was taken by the International Court, ignored the recognized immunity of state leaders and ministers of foreign affairs. And the International Court of Justice considered that ministers of foreign affairs will benefit anyway from immunity and total invulnerability. It's a little bit a strange decision because by this judgment, the court came back to its position adopted by international law. Firstly, it operated a distinction between perpetrated acts on official title, and those perpetrated privately. And secondly, it accepted to abolish all immunity in case of serious violation against human rights. Again, here I refer to the Pinochet case. The court, and especially the Chamber of Lords, had refused to take into consideration the immunity of Pinochet because cases of torture didn't depend on the normal functions of a leader of state. Nevertheless, the mention in the judgment of all immunity after the end of a minister's terms leaves room for hope in Belgium. And indeed, since the court has not pronounced itself on universal competence, it distinguishes well the during and the after in the appliance of an official function. We can conclude that the Belgian laws have only temporarily grown away from the jurisprudence while waiting for the stopping of the functions of the leader of the state. Even if the International Court of Justice has not completely pronounced itself on the legitimacy of the universal competence, some judges have nevertheless expressed themselves about this. It's a little bit strange, that the judicial power, judicial international power, can also pronounce itself by the way of, firstly, by the way of its president, who declared that universal law doesn't admit universal competence. It admits even less universal competence by default. And he adds that the court, if it had been encountered to the specific question, would have declared that the Belgian judge was wrongly found in power of prosecuting Mr. Herodia while prevailing of universal competence incompatible with the international law because he was Minister of Foreign Affairs in charge. However, in another, I can say, dissenting opinion from the judges Higgins, Kooijmans, and Bergenthal, they expressed exactly the opposite of what was developed on ideas by their president. And according to them, the competence Belgium has assumed is not contrary to the international law. The three judges considered, and I quote now, criminal jurisdiction should not be exercised without permission within the territory of another state. The Belgian warrant of arrest envisaged the arrest of Mr. Herodia in Belgium or the possibility of his arrest in third states at the discretion of the states concerned. This would, in principle, seem to violate no existing prohibiting rule of international law, unquote. It's exactly the opposite. So you can imagine that for my country, with the laws we have, we don't know what is the state of law internationally of all these declarations. And following to this judgment of the International Court in the Herodia case, there was also a law proposal for the conformity of the Belgian law with the international principle and the adoption of the statute of the International Court of Justice, and it was brought in the parliament. And we thought at that moment, now we will have peace and rest and clarity and all what is necessary for security of the rights, but the complaints started again. Now complaints against political and military leaders following the American intervention in Iraq caused fierce reaction from the Americans, culminating in the threat of moving the headquarters of the NATO from Brussels, from Belgium. The first complaint was introduced in March 2003, and relative to facts during the first Gulf War, they targeted Mr. George Bush Sr., and members of his team, and also the former Secretary of State, Colin Powell, for the bombing of a shelter during the first Gulf War in 1991 that had caused 403 deaths and ended in embarrassing, seriously, that you can imagine, our Belgian diplomacy. Some had estimated that the Belgian law caused a serious problem, considering that the NATO headquarters were just located in Brussels. And therefore, they warned also Belgium. I remember very well that period in my time in government. Consequently, the law proposal of 2003 was modified and foresaw that when the case didn't entail any link with Belgium, the federal prosecutor that we installed in the meantime and who is working for the international relations could, in certain cases, refuse to demand a judge to investigate the complaint if there is not any link with Belgium. Furthermore, the proposition entails an order of the Minister of Justice, what we called negative injunction, and that is materialized by the possibility to send the complaint to the state upon which the territory, the infraction has been committed, or from where the author is the national. So you see, we were in difficult periods. Who came much more difficult after Plain's complaints against the American General Tommy Franks, well known from the Iraq War, and that leads to serious reaction this time from Mr. Donald Rumsfeld, Secretary of Defense. After having qualified the complaints as absurd, he denied also the authority of the Belgium judge to judge American leader. And again, there was said by the Americans that the new construction of the new headquarters could become in a very difficult situation. You can imagine we were at that moment in the height of an election campaign, but nonetheless, our Belgian Minister of Foreign Affairs at that moment let know that we should change the law, and it was done the 5th August 2003 by an initiative taken not by the government but by the Prime Minister, only to say how important this was estimated. We have also encountered other problems who led to an incredible political imbroglio. This is the total case, but I don't want to go more in detail. Here it was only a complaint from Burman people, for Burmanian people. One of them was also in Belgium recognized as a refugee, and he also was thinking that Total, it's a moral person, could be involved in genocide. Our Supreme Court have taken a decision by which Total was in favor of Total and rejected the order of the public prosecutor and the prejudicial question that there was also for the Constitutional Court. Let me conclude. And in my conclusion, I can say that the story that I give over my country with the response via the universal competence is a little incredible. Can it be criticized? The 1993 decision was laudable, but the desire to attain an ideal of universal humanitarian justice led to underestimate the necessary efforts. Did the Belgian justice has at its disposal the necessary means to investigate, to gather the evidences, collect testimonies relative to criminal acts that are often committed thousands of miles away from Belgium? What legitimacy could Belgium invoke to examine the acts committed in a political, social, and cultural context of which it ignores the subtleties? These were questions that were also my questions in the period of 2003 and who were raised again a few months ago by a law professor from the Brussels Law School. I want also to refer to the recent events in the Arab world. Those reinforces the necessity of strong international justice. You know that on the 26th of February 2011, the Security Council decided, and I come to the citation, seized the prosecutor of the International Criminal Court of the situation of Libya is the theater since February 2011. The Council estimated that the systematic and generalized attacks committed in Jamahiriya against the civilian population could constitute crimes against humanity. But you know that Libya, in the meantime, is not a part of the status of the International Criminal Court. The Criminal Court resembles more to be a criminal court on standby. So you see there is a lot of effort to make. Nevertheless, looking back in history, I think that the Belgian legislator of 1993 was a precursor for an universal criminal justice. It was worth to risk, but demanded more shrewdness and rationality to come to good conclusions. Nevertheless, the words of Voltaire stay more than ever applicable. La plus belle tâche de l'humanité, c'est de rendre la justice, or free translated, the most beautiful task of humanity is uphold the law. Thank you very much for your attention.